Welcome to the Gulf Coast Center's Corporate Compliance and Rights Protection Training. I'm Cindy Cagg, the Corporate Compliance Officer and Rights Protection Officer.
And I'm Linda Bell, the Center's General Counsel.
Please be sure to sign in on the sign-in sheet you'll find in the training room. It's important that we have your signature, so we'll have evidence of your training participation. There are two forms you'll need to turn in at the end of the training. One is the employee affirmation. That's required of all participants. The other is the notice of prohibition. That is required only of new employees. You may be wondering why you need to attend compliance training. Well, the answer is simple. It's because compliance is everyone's responsibility. Billions of dollars are improperly spent in healthcare in this country every year due to fraud, waste, and abuse, and we should all be concerned about that. Here at the Gulf Coast Center, it's everyone's responsibility to assure that our organization remains in compliance. We do that in three ways. First, we prevent issues by following our business code of conduct. We detect and report concerns. And finally, we correct any non-compliance that we find. There are differences between fraud, waste, and abuse, and you'll find those definitions on slide 3. Primarily, the difference is this. Waste and abuse, though they do result in improper payments, do not include intent and knowledge to defraud the healthcare plan. Fraud, on the other hand, does include intent and knowledge, and it's a purposeful act to execute a scheme or attempt to execute a scheme to defraud the healthcare program. The healthcare fraud statute makes it a criminal offense with imprisonment up to 10 years and fines of $250,000. The reasons for a compliance plan are then pretty clear. It's to prevent unwanted things from happening around here. They're going to get us in trouble, either intentionally or unintentionally. It's to help the organization find out about issues that do take place so they can be addressed. And if unwanted events occur and we're not aware of them and they're brought to our attention by a regulatory agency, we need to be able to demonstrate that we do take compliance seriously, we do conduct trainings, investigations, and hopefully that would help mitigate any negative impact we may have from that situation. There are 7 elements to an effective compliance plan, and these elements are given to us by the Office of the Inspector General. First is written standards of conduct for all employees, contractors, and volunteers that promote a clear commitment to compliance. That is our business code of conduct, and we'll cover that a little bit later in the training. The second is the appointment of high-level individuals in the organization to oversee the compliance effort. That just means that as the compliance officer, I don't have levels of supervisors to go through. I report directly to Linda, the center attorney, and so compliance issues are right to management promptly. Number 3 is due care taken by the organization to not delegate responsibility or authority to those who may engage in illegal activities. That just means that we best not be hiring folks that have just been in another county committing healthcare fraud. We need to be checking the exclusion database for all new hires, and actually we check it monthly in contracts management and HR to assure that all of our employees are not found on any exclusion list. Number 4 is effective training and education programs for all employees and volunteers. That's why this training is required of new employees and annually of all employees. It's very important that we demonstrate that we do take compliance seriously by training our employees on what the expectations are of their behavior. 5 is monitoring and reporting systems to uncover potential problems and to encourage the reporting of potential problems by employees without the fear of retaliation. There's a number of things there we need to talk about. The first is monitoring. Monitoring is everyone's responsibility, and it starts with the individuals who enter information into the system through progress notes. You have to be absolutely certain that the information is accurate. The right person, place, time, tied to the recovery plan, all elements are accurate. There's also monitoring that takes place at the program level by program managers. We have a QM department that reviews documentation. I may review information if we're involved in a compliance investigation. Billing department reviews information. It's just important that we have multiple layers of checks and balances to try to catch any concerns that might show up in our documentation. The other part of this is the reporting of potential problems. It's very important, like we stated in that earlier slide, we do have to detect and report issues so they can be addressed. So if you find a concern or you have a suspicion of a concern, you must report it. And then finally, employees need to feel free to report without fear of retaliation. We do have a no retaliation policy at the Gulf Coast Center, and it's important that individuals are aware of that. Number 6, disciplinary systems for all non-compliant employees and their managers that are consistently enforced at all levels of the organization. As you can imagine, disciplinary action must be taken against staff who commit fraud or other types of misconduct, and it must be consistently enforced across the board to everyone. Number 7 is reasonable steps taken to respond appropriately to detected offenses and prevent reoccurrence. As you can imagine as well, we have to make sure that whatever that issue is that was discovered is corrected, and we try to take steps to make sure that it doesn't happen again.
As we indicated at the start of this training, I'm Linda Bell. I'm the Center's General Counsel, and I'm going to be going over some of the laws and legal issues within our corporate compliance plan. First, I want to go over the three primary categories of fraud and abuse. Now, these are the ones that we typically deal with at the center, so that's why we're limiting the conversation to these three, even though there are other areas of fraud and abuse that I will kind of touch on in just a bit. Those are improper billing practices, misrepresenting qualifications, and improper business practices. Now, when we're talking about improper billing practices, and this would be the slide on page 8, we're talking about upcoding, phantom treatment, or delivering treatment that's not necessary. For the center, though, specifically, we've dealt with upcoding and phantom treatment. We've had staff in the past who pretended to be seeing clients when they actually were getting their manicure pedicure done. We've had mistakes by staff in upcoding information when a lower service actually was provided. And that situation basically rolled into a misrepresenting of qualifications also because the notes were being done by a QMHPP when the note required and they were billing at a QMHP rate. And so while that was just a mistake, it was not intentional, that would fall into the category of misrepresenting qualifications as well as improper billing practices. Now, when we're talking about improper business practices, that's when we get specifically into the laws associated with corporate compliance. So we're talking about kickbacks, cost report issues, where we do things to actually enhance our profit illegally. So we're talking about the actual laws on page 9, the federal anti-kickback statute, the Stark law, the Texas illegal remuneration statute, civil monetary penalty statute, the Federal False Claims Act, and the Medicaid Fraud Prevention Act. The first law I want to discuss is the anti-kickback statute. The important part of the anti-kickback statute is it applies to all staff, not just licensed staff. So it could be the receptionist who has a deal with a doctor who actually has a private practice, that when any clients come in or consumers come in and they have a good third-party payer insurance, he has a deal with our receptionist that she will refer them over to his private practice. And every time she refers a good payer source over to his private practice, she receives a $25 gift card to Target. That $25 gift card to Target would definitely be a kickback and in violation of the anti-kickback statute. And so whenever you receive a benefit from something you're doing for someone and they actually receive another benefit on their end, there is a good chance you are violating this statute. And as I indicated, this applies to everyone. I used a receptionist in this example and the doctor because if you look at the Stark law, the self-referral, the doctor is in violation of this law. The Stark law, actually, you do have to actually be a physician assistant, or someone at that capacity. When that person accepts the illegal referral that the receptionist provided for him, he actually is in violation of the self-referral law because he can't receive referrals to his business in a set-up relationship like that or an entity that he owns. So he actually violates that particular law. The one thing with those laws is they come with huge fines. When the doctor actually violates that law, that's a $10,000 to $25,000 fine for each time that she actually referred him a client or consumer. So this could get extremely costly for him and for her because her fines associated are the exact same. So that $25 gift card that you get for Target will never be worth that $10,000 fine. So always keep in mind, you cannot make those referrals to an entity because of a request by one of our doctors or one of our LPCs, therapists, and so forth who have private practices. Anytime you have an issue where you think that you are in a anti-kickback or a kickback situation, please call me or email me so we can actually look at the issue. Sometimes there's issue with pharmaceutical companies, and we actually have taken care of this years ago when they used to bring in the free lunches, which are considered dine and dash by the law and are considered a violation to a certain degree. So there are things we have to put in place in order for you to have that meal associated at lunch from a pharmaceutical company. They have to do a training and things like that. It has to be the appropriate people in the meeting and some other rules we have to follow. We do have guidelines on vendor gifts in this type of situation, and I'll be more than happy to share that with you if you're put in that type of situation. Now, the Federal False Claims Act is one that we probably should be most concerned about. And that's when you submit a claim or cause a claim to be submitted falsely. The fines for this, though, range really high. It sounds low because I'm not saying $10,000. I'm saying $1,100 to $1,500, but it's for each claim. So you send in multiple claims a day, so you have to multiply that $1,100 to $1,500 by the number of claims that have actually been submitted, and then you multiply that by 3 because there's a triple damage on top of those types of intentional reckless claims where you just ignore the what's being provided and provide a false claim for payment. So the fines get really big, and then unfortunately you are also put on the provider exclusion database. You have the opportunity to spend some time in jail, like 5 years. And so there is a huge ramification for submitting a false claim for services that are not provided, or intentionally submitting a false claim just so you can receive payment. The Medicaid Fraud Prevention Act it's similar to the false claims. It's just on the Medicaid side, but it's the same issue of intentionally submitting a claim to Medicaid that you know is false. And so the remuneration is exactly the same, but you will be put on a Medicaid exclusion database, and that's for no less than 10 years. One of the significant ramifications of fraud and abuse is landing up on the provider exclusion database. The provider exclusion database is used primarily when someone commits fraud under the Medicaid Prevention Act or under the False Claims Act. You'll be put on the database for up to 10 years. The reason I say it's significant is if you're on the database, you cannot actually work for anyone who bills Medicaid. Previously, I used to say, oh, you could work at a hospital, but you'd have to work in janitorial or food services, but they actually came back and clarified that rule. They cannot have you on the payroll if you actually are in the database. This is not just for doctors or nurses. This is for anyone who actually commits fraud. So it's very important that you understand this rule. There are also other reasons you can end up on the database. Say your license is revoked or suspended. There's some program-related convictions. Of course, patient abuse and neglect. And of course, and one that people most likely won't think of is the default on your health education loans. So we have dealt with a few of these issues and the provider exclusion database because we once had a doctor who defaulted on his healthcare loans. So we had to work out a situation there and work with the entity as well as worked with his loans to get that issue taken care of so he was off of the database and we could continue to bill. So it's a bigger issue than what most people think. This is not a situation where they tell you you're going to be in the database for 10 years and you're off. Typically, you're in the database for at least 10 years and then you actually have to file for an appeal to actually be taken off. Again, individuals who are on the database probably have gone through a certain level of significant fines. The civil monetary penalties, again, are $10,000 for each claim or service that you fraudulently submitted. There's an assessment up to 3 times for each claim that was submitted. Of course, any violating entity, the Gulf Coast Center could actually end up on the database. But most of the time, it's the individual who is going to end up on the database. So everything is significant under fraud and abuse, and the ramifications are significant under fraud and abuse. One of the most important things we need you to do is report when you think something is wrong at the center. There are protections in place for reporters. There's actually federal protections for reporters, and that's on your slide on page 15, the Whistleblower Act. It's also called the Qui-Tam Act is actually the official name. So technically, once you report fraud, say you feel as though your coworker is committing fraud, you've reported it to the Corporate Compliance Officer, Cindy Keg, and nothing has been done. The fraud has continued. We failed to follow our policy and procedure. Technically, at that time, you can actually file a claim or complaint with the Attorney General's office, and they will look into the matter. Now, not every claim is looked into by the Attorney General. Sometimes they just give you a right to sue letter, and then that means you can go hire your own attorney. You sue in the name of the state, and if you win, you'll receive around 20-25% of the proceeds. But this is a long process. It's not like you sue in June and then you have a court hearing in December. It actually takes years before these cases actually make it up through the court system. A lot of times whistleblower acts come from disgruntled employees, so if you're the person committing fraud and you get fired, you can't really file a claim with us at the Attorney General's office and try to think you're going to get the 25% if you're the actor who was committing the fraud. But again, a lot of times complaints do come from disgruntled employees who may or may not have used our process. Cindy Keg does look at all compliance reports. There's no favored person who actually gets skipped. So in the event you think fraud and abuse is actually occurring in your program, Please follow our policies and procedures and submit that information to Cindy Kegg.
On slide 16, you'll see how to report compliance issues. You should also have this poster in all the facilities with the same information as a reminder of how to report. It states as a general rule, report to your supervisor. That's simply because in a compliance investigation, I am going to involve the supervisor because it is, after all, their program, so they do have some responsibility for the actions that take place under their supervision. However, you have options. You don't have to go to the supervisor. You can come directly to me if you'd like. And there's all the ways that you can reach me. My office is here at administration. There's my phone number, my email address, my physical address, fax number. The point is you have multiple ways to get the information to me so the issue can be addressed. Action taken in detected compliance offenses and other confirmed cases of misconduct. This also includes misconduct as it relates to abuse, neglect, and exploitation. We'll have a whole section on that later, but I want to go ahead and mention it here because the responses are the same. First, there are considerations that are given to any type of offense. It's the seriousness, the circumstances. Has this ever happened before? If it has, how long has it been? I mean, the center really does look at situations and can take into consideration a lot of factors when misconduct occurs. Possible action can be anything to include required training. Perhaps you need retraining, a written reprimand. You could be put on probation. You could be demoted, reassigned, terminated, or reported to a licensing board. It just depends on the offense. When it comes to abuse, neglect, and exploitation, there's other places that this information will go. One of them is called the CANRS system. That stands for Client Abuse Neglect Reporting System. That is the statewide database that keeps track of all the people that work in this healthcare system of DSHS, DADS, HHSC, that have had a confirmed case of abuse, neglect, or exploitation. What that means is, if you have a confirmed case here and you're terminated or you leave, and at any point in time you go to another agency within this service delivery system, another community center, state hospital, state supported living center, and you attempt to get a job, HR is going to check the CANRS database. And if you're in there for a confirmed case of abuse, neglect, or exploitation, you're probably not going to get that job. That does not go away. It stays there forever. We've had some people experience that by trying to get a job 10 years after an incident happened here, and it was impossible. They tried really hard. They contacted myself, they contacted their legislator, they contacted the state, and there was nothing anybody could do about it because once you're on that database, you stay on that database. The other place this confirmed case will go is called the Misconduct Registry. It's just another database where names are put. Of course, the whole purpose is to protect the people that we serve from people who are going to engage in abuse, neglect, or exploitation. When it comes to compliance offenses, the other thing that may happen is a corrective action plan. If the offense is not so egregious that termination is the result, it may just result in the staff and the supervisor having to write a corrective action plan to make sure that that particular issue does not happen again. And then finally, reassignment may occur during an investigation. It doesn't happen in every investigation, but an example of what it primarily does is when we have an allegation of sexual abuse against a person in services. When that happens, of course, we're going to remove the staff person from working with that individual during that investigation. And it's not because we think the staff is guilty. We're trying to protect everyone. If it turns out that the allegation is true, then we have protected that client from that staff in any further instances. If it turns out it was false or unconfirmed, then we've protected the staff from any further false allegations. But again, not all investigations are like that. A compliance investigation, you may not know about it. You may continue to do your job while it's being investigated so we can get to the bottom of the matter. Slide 18 is responsibilities of supervisors and managers. Of course, the supervisors and managers have to comply with all the expectations of the compliance plan and the policies and procedures, but they have the extra responsibility of assuring that the people that they supervise also comply with all the policies and procedures and the expectations of our corporate compliance plan. The bottom part in that slide there says that supervisors can be held accountable for failure to detect noncompliance within their program. That just means that if there's some egregious violations going on in the program, fraud's being committed right under the supervisor's nose and they don't know, then that supervisor can be held accountable if that is actually confirmed, because supervisors need to know what's going on in their programs and be responsible for the actions of their staff. Now we're on slide 19 and we're going to begin talking about the Business Code of Conduct. You'll find the Business Code of Conduct in your handout packet. We're going to have a few slides that pertain to the Business Code of Conduct, so there may be some flipping back and forth. But first of all, look at your Business Code of Conduct. The first page has the mission, vision, and values of the center. Be sure to read those That's why we work here. That is what drives us here at the Gulf Coast Center. 1 and 2 is statement of purpose and ethical standards. That just states that we're going to exhibit behavior based on honesty, integrity, and a sense of fairness, and that we're going to maintain the highest ethical, legal, and professional standards. With ethical standards, again, if you have a licensing board, you're going to have to comply with those ethics as well. And then it states also that we're going to make every effort to avoid even the appearance of illegal, unethical, or unprofessional behavior. Just be aware that the appearance of can land you in an investigation. If it appears that you're doing something to someone, they may report you, but always remember, if you're not doing anything, there's no way that is going to be confirmed. But appearance of does result in investigations sometimes. Number 3 is leadership responsibilities. This speaks again to that slide we talked about a few seconds ago with regard to supervisors and managers. Our leaders are expected to be role models. They're expected to be a good example for the people that they supervise. They're expected to provide sufficient information so people know how to do their jobs and how to comply with all the laws and regulations and policies and procedures. We promote the highest standards of ethics and compliance, and we never sacrifice ethical or compliant behavior for the pursuit of business objectives. The best example of that for us would be in those instances sometimes where a supervisor may tell the people in the program that from a budgetary perspective, our revenue is down, and we need to make sure we make those contacts and we get that Medicaid money up. That would never, ever mean that you were to go out and make unnecessary contacts or to do anything illegal or unethical. If you ever think you're receiving a directive like that, you need to contact me immediately, because that is not okay. We do not sacrifice compliant behavior for business objectives.
Number 4 in your business code of conduct is conflict of interest, and there are 2 supporting slides on page 20 and 21 that further describe this particular area. When we're talking about conflict of interest, I'm looking at this in 2 different ways: your conflicts that are personal and your conflicts that relate to contracts management. Now, when you're looking at conflicts of interest in general, which is the personal, you need to make sure your personal activities do not conflict with your work at the Gulf Coast Center. So it can't conflict with our business code of conduct, with our mission, vision, and values, or with our operations of the day. For example, you may have a second job selling Mary Kay, which is fine, and you sometimes sell it to your coworkers. Well, you can't sell Mary Kay all day long and not be doing your notes or seeing clients. You can't be doing makeovers in your office with your office door closed for a whole hour when you should be doing business for the center. Another example of personal conflict would be, say you're having a personal issue where you're amorous with a couple of coworkers or one coworker, and that situation goes bad, and then we start having drama in the clinics. If that drama actually interrupts business operations, if we start having to deal with phone calls or all these other individuals having to call the center and having to feel this personal issue, that is actually a conflict with the Gulf Coast Center's business operations, and there is a potential for term associated with that. Now, when we're talking about conflicts that result because of contracts management, there's actually a rule. This is actually a law within the Texas Administrative Code that limits who we can actually contract with if there's a relationship or association with someone at the center who's involved in billing, contracts, the finances, and so forth. So whenever we have an individual who is employed by a contractor, you receive consultation, you might own some stock there, you have a family member who's within the 3rd degree of consanguinity, which actually means your mom, your adult children, your sisters, those individuals, we have an issue contracting. I can clear some I cannot. An example would be, say, Rick Elizondo, who's a center CFO, is sitting on the board of ADA. Well, Rick actually determines the budget for those contractors under recovery. So for him to be on ADA's board, there's a chance that someone could call foul, that would be a perceived conflict. Rick is the one who establishes and approves the rate of pay as well as the do not exceeds for that contract. So if ADA looks like they're receiving a lot of money, someone could easily argue they're receiving all of that money because our CFO is actually sitting on their board. So we do look at the board of directors. We actually have a policy where you're supposed to report your second jobs to me. The importance of that is not to infringe on your personal business. The importance is I need to know where you work so I could determine if there's going to be a conflict. Depending on which area you work, that may be the only place where you know contracts, when in fact we have contracts across the center and all the programs. So if you work in IDD services, you may not know all the contracts that we have in recovery services or mental health services. So you may not realize that there's a rule violation getting ready to occur. So that's the importance of letting me know your second job. There's no other reason that I actually need that information. And then you receive an email from me saying there's no perceived conflict, and we move on. There have been occasions where I did have to actually look at the conflict because the person, they interlope too much within our financial issues and the other entity's financial issues, and it just would not ever clear. So there is a rationale for us knowing that information, but again, slides 20 and 21 actually spell out the issues surrounding conflict of interest to keep everyone clean and fair. But if you have an issue or you're concerned about whether or not an activity is a conflict, please feel free to email me and we can discuss it and make sure everything is fine. Number 5 on the business code of conduct is gifts and favors. As a center employee, you can just not randomly accept gifts from consumers. We do have policy limits. Our policy limit is $50. That actually was raised some time ago, and it fits in with what the state allows. So if a client or consumer, let me clarify myself, if a consumer wants to provide you with a gift of $50, there is no problem. It is not a policy violation. However, if you're concerned about the gift and its price, shoot me an email, I'll clear it, and that way if it pops up again, you have an email from General Counsel saying this was not actually in conflict with our policy, and you keep your gift. You know, a lot of people pay attention to when people get gifts. I've gotten a call on policy violation because someone saw that gift in the newspaper over the weekend, so they knew that it was actually over our policy limit. So it's easier to just call, have me clear the gift, and we have no problems. Now, if you work in recovery services, you cannot accept a gift regardless of what it is, regardless of how much it is. That is against the recovery program rules from the state level, not from the Gulf Coast Center policy level. So recovery programs cannot accept gifts at all. Now, in the wintertime, there are times when people like to bring in tins of cookies and popcorn and things of that nature. There's no problem with y'all putting that out in the community room, lunchroom, and everyone sharing in that. But again, it is a significant limitation for recovery. So if you ever receive a gift of something you think is perceived to be a gift, please run it by myself. And if I'm not available, touch base with Cindy Kegg so we can make sure that there are no issues there. So just check into the gift policies and favors. Again, there are special rules for pharmaceutical companies and vendors, so we can actually discuss that when you get into one of those situations. But gifts from our vendors is a policy violation also. If one of our vendors who's trying to get a contract decides he wants to do lunch for all the staff at Mainland CSC and he doesn't have the contract, it looks like it may have influenced my decision to contract with that person. So there's a couple of little tweaks and ins and outs that are involved in this situation. So again, just call myself or Cindy and we'll be happy to go over those with you.
Number 6 on the Business Code of Conduct is compliance. That section just summarizes all the slides that we covered at the beginning of this training having to do with our commitment to complying with all the federal and state laws and regulations with an emphasis on preventing fraud and abuse. It states that we're going to conduct audits, that we're going to detect compliance offenses, initiate corrective action where necessary, report to the appropriate oversight authorities, and address consequences with employees as appropriate. Number 7 is accounting and reporting. That actually speaks to everything that we put on record, whether it's a progress note, a cost report. It states that we will maintain and submit accurate and honest records related to all billing, reporting, and that we will actually document services that were truly rendered. It's very important that all of our information is exactly accurate. And we have a number of auditors that are in our organization on a regular basis looking at our information, and that's great. They should be, because we should be a good steward of dollars, and we need those outside agencies to come in and do those audits.
Number 8 on the Business Code of Conduct is corporate resources. When we speak of corporate resources, we're speaking of all the items in things that we own at the center. That would be the vehicles, the computers, the phones, the chairs, the tables, all the stuff that we own. We have an expectation that you will protect it and take care of it as if it were your own. So for example, if you're driving a center vehicle and you park it, we have an expectation you will lock it. We have an expectation you will park a center vehicle in a well-lit area, not an area that it would be prone to theft. We have an expectation you will not be using our postage machines for your personal mail. You will not be using our gas cards for your personal car unless you're authorized to use it for your personal car. Most gas cards are assigned to a center vehicle, not a personal vehicle owned by staff. Any of those violations tend to get individuals termed. We've actually had individuals driving center vehicles, and they fill up the center vehicle, and then one of their relatives drives up their personal car, and they actually move the nozzle from the center vehicle over to the personal car and fill up a personal car. Luckily, gas stations always notice this, and gas stations always send me the film, the footage of our staff doing that, and that does end up in a term. So again, corporate resources, we have quite a few. The laptops are starting to cause an issue. The phones are starting to cause an issue because they're getting lost and stolen. But we need you not to be negligent in your care of our property. Accidents do happen. Things get stolen. There are thieves out there, and that's not staff's fault. However, make sure you have things locked up and secured if they're on your person, and you are actually taking care to protect our assets as best as you possibly can. Number 9 on the Business Code of Conduct is political activities. As a center employee, we will never ask you to go out and lobby for us. There used to be times when there were say one of the state representatives was having a party down in Galveston or a meet and greet down in Galveston, and Mike Winburn, the previous executive director, would ask you to attend. He was not asking you to attend because he wanted you to lobby. He was asking you to attend so you can educate the people in the room on the Gulf Coast Center, your program. Not ask them for money, just tell them, what does Lone Oak Ranch do? That's the only reason he wanted y'all out there, to tell them what Lone Oak Ranch did. Not to lobby about your house, not to try to get us more money for horses, but to just describe what was going on. We will never ask you to go lobby for us. It's actually against the law for the centers to use the money that we receive from the Department of State Health Services, now Health and Human Services, to receive that funding and go lobby with. So if you ever felt that your supervisor or someone in executive management is asking you to go to Austin to lobby, or asking you to attend an event in our service area to lobby, please immediately contact me so I can step in and we can address that issue before a violation occurs.
The form that I mentioned in the beginning of the training, the notice of prohibition, this is what that pertains to. Your signature on that form indicates that you've been told that you cannot lobby, and you've been provided the information that Linda has just presented to you. New employees only need to sign that and turn that in at the end of the training.
Confidentiality is number 10 on the Business Code of Conduct. You probably are sick of hearing about HIPAA and encryption and safe to send and all those good things that we have to be aware of here at the Gulf Coast Center. Just because you work at the center doesn't mean you get carte blanche information on anyone who receives services here. You have to be involved in treatment and care. Now, can a colleague call and ask you your advice on a situation? Yes, they can. That is not a violation. But if something happens in Brazoria County with one of the consumers and you think it's funny, or you think it's gross, or you just want to tell this story because it's not one of your typical days, you cannot use client identifying information if you call someone at Mainland CSC who has nothing to do with the care of that individual. Doing so technically is a violation of the center's policy and procedure, and you are breaching information regardless of the fact that both of you work here at the Gulf Coast Center. There is a need to know in that particular situation. There are situations when certain individuals can get information, law enforcement, but law enforcement does not have the ability just to walk up to the door and say, I want the information on the client named Cindy Kegg. That's not how it works. What they need to do is there needs to be a need to know. Is Cindy in the car and getting ready to be transferred to St. Joseph? There has to be some type of emergency need to know in that situation for you to give information to the actual police. An emergency room calls because they have Cindy in the emergency room and they want information on her care or her last visit. Do you need an authorization for that? No. You can share that information. HIPAA allows you to share information for treatment operations and healthcare concerns. So you can share that information with that entity, but there has to be a treatment, continuity of care issue argument that we could use. Typically, we always get an authorization for release. Is it always necessary? No, it's not always necessary. It's just always safe. But if you question whether or not you legitimately need that authorization for release, because the law does give you quite a few times when you don't actually need it, call me. Err on the side of caution. Check with me first, and I'll make the determination on whether an authorization is actually needed. But in an emergency situation, whenever there's suicidal ideation or homicidal ideations involved, do know there's going to be an exception in the law, and you're going to be able to give information to a doctor, an emergency room, or law enforcement who is in the midst of transporting or things of that nature. So we do have some things in place with like UTMB and our actual contractors. I actually have the language in their contracts So they actually are covered because they are a treating provider, just as we are a treating provider. So technically, you do not always need an authorization for release. But please go ahead and follow our policy and procedure. And we do like to get them in most cases so there's no arguable issues on whether or not confidentiality should be kept in those situations. You have several slides on confidentiality in your packet, which start on page 23. Of course, I am not reading these or going through them. They're there for your information, and I'm just summarizing a lot of the information or the issues that we have dealt with at the center in regards to HIPAA and confidentiality and breaches. As I say the word breaches, which is a nightmare here at the center because for some reason we've had devices and so forth stolen, which is not typical. As you know, and as I've said several times, whenever we have a breach over 500, that means we have to actually do a media release and let people know, let the community know that we've had a significant breach. There's always the risk of that when we're talking about laptops, and especially with staff who have not been protecting their information on the laptop. For instance, you should not be saving information on your C drive. Because your C drive, if they're able to get through our password protection into the computer, they could get to that easily. That's not stuff that's going to be on our server. Like for me, I have an H drive for my stuff. So if they got my computer, they would never get to my H drive stuff, which is where all my confidential documents actually are. And I don't really keep anything in my C drive unless I'm actually working on the weekend for that moment. But it's never client identifying information. Please start being more careful with your emails. We've had significant number of breaches because of staff's failure to use Safe to Send. You should, and I always tell you, just think every single time you do an email, you should encrypt it. That should be your question you ask yourself before you hit send. Is there a reason this shouldn't be encrypted? Not why should it be encrypted. You should assume everything we send outside this agency should be encrypted unless you have a reason not to have it encrypted. That way we can stop with a lot of these breaches that are occurring because you are failing to remember to put Safe to Send. So you should just assume anything you send in, unless it's internal, is something that needs to be hit Safe to Send. And then you think, oh, well, maybe this shouldn't be because of X. And if you have a reason why it shouldn't be Safe to Send, then take Safe to Send off. Otherwise, send it Safe to Send so we're protected. Otherwise, I'm reporting quite a bit to the OIG of all these breaches that are occurring due to the emails, the lost laptops, the phones. And the last thing we need is actually an audit, because staff really are doing a good job. You know, the thefts of the vehicles really have not been the staff's fault, but they have been issues that have been completely complicated because of the breach rule. And we do need to notify those individuals whose information is breached, regardless of whether or not it's just a name or if it's a name and other identifying information. It still will be qualified as a breach. So please be very cognizant when you're sending emails, because the emails have become a big issue. And if you do travel with our devices, the laptops and phones and such, make sure you secure them. Make sure you lock your car. Make sure you have them somewhere safe so someone can't just look in the car, want to break your window and steal our stuff. Texting should never be a form of communication. If you are texting with someone, I'm going to really need your supervisor or myself to have approved it. Texting is not an appropriate form for communicating with clients and staff at all. So unless there's a reason you should be communicating via text, texting is not something that we support or actually communicate as allowable. So please stop doing it. If you receive a suspicious email, do not open it. And I say suspicious in the sense of, you know, you don't have a cousin in Africa getting ready to send you $1 million. Don't click on that email link. If you don't have relatives in a certain country and someone's telling you their situation and they need help, please do not click on those links. Those links tend to have viruses and so forth on them, and then when you click on them, it infects our system. So if you think something's suspicious or it's something that you really are concerned about, shoot it over to someone in MIS. I've always sent my stuff to Robert Edeker. He checks it. Every time I've sent him something, it actually was something that was an issue that I shouldn't have opened, and I had not. And so always check first if something is suspicious, because we do not need our system going down for reasons that we could have actually prevented. So if you question something coming through on your computer, please shoot it over to MIS so they could clear it before you actually open it, not after it's affected our system. So again, MIS is here. I'm here, Cindy's here, so if you have breach or HIPAA questions, please check with us. Another really good resource is Liz Bennett and Avis, who work in medical records. They are very fluent on the medical records aspect and what can and cannot be released. So they are another resource. If you actually receive a subpoena with someone actually wanting records, check with Liz if you're not fluent in how to do the records. Liz actually is the one who typically completes our business affidavits to send records. Sometimes they want you. If they want you, yes, you do have to respond to a subpoena unless someone cleared you not to. So there's an attorney's name or a contact name at the bottom of the subpoena. If you don't know the client that they're asking about, if you have no real information about the client they're asking about, technically if you call that number and told them that, they're going to tell you you don't need to go to court. Sometimes you get a subpoena that has like 5 dates at the bottom of it telling you you must be available for those 5 dates. You're never going to be available for those 5 dates. You just need to call and let them know. Can they text you or call you an hour before they need you, and then you can go to court then. I have not found one attorney that has not been reasonable in the fact that our staff are providing services, so they do accommodate a schedule issue, but they need to know beforehand. So sometimes they will subpoena everyone in a program because they don't really know what they're looking for. If that's the case, let me know who's all subpoenaed. I can call the attorney, see who they really want, what information they're really looking for, and we can narrow down who actually needs to go to court. Because again, we all know it's very disruptive when you receive a subpoena. And have to counsel and not go see clients or consumers and things of that nature. But let's deal with it on the front end so there's not any problems, because a subpoena is a personal issue. Don't get scared if you're receiving a subpoena. It's nothing to run from. The subpoena is not actually for you or your court issue. It's for someone else. So the only time you will have a negative effect with a subpoena is if you run from it and try to prevent service. There is a law against that, and I know in Brazoria County, they take that very seriously, and Jerry Yenny will come after you for trying to avoid a subpoena. So if you have a subpoena issue, please contact me. But at the end of the day, if you've seen this person, you have really good information on this client or consumer that they're trying to deal with in court, you will unfortunately have to go to court. But if there's a problem, please always check with me before, so you're not releasing information or putting yourself in a difficult situation. Now, with HIPAA, there are other things you need to think about too when you walk in your office. How are things arranged? Is my computer sitting right here and people are walking in behind me so they can see everything on my screen? You know, are you leaving personal health information out and going on vacation or going to the bathroom or, doing things like that? Whenever you have healthcare information, someone else's private healthcare information accessible like that, technically you are violating HIPAA and there's a chance for an issue to occur. There was a situation one time in mainland CSE, the young lady who was actually over medical records, she actually walked out of the office, went to the office right next to the door, because that's where closed things were filed, where Carolyn Rose was walking around with the HIPAA monitor. And guess what? The medical records room was open and unlocked, which is a violation. So we got dinged. But she literally had just walked out of there and said hello as she passed them and walked into the other office door. But regardless, certain things are supposed to remain locked and inaccessible to others, and the medical records room would be that, especially if you're not sitting in it. So again, think about where everything is located in your office. Is there a chance people can read over your shoulder? Are you a person who talks loud like me? So HIPAA kind of is a problem because my voice travels through walls. You need to think of that and temper yourself. Minimal information being disclosed because of tone or because we have thin walls, that technically is not a violation. It would have to be a little more pervasive than that. But please be aware of situations where we do have thin walls, or that you're allowed, or that there's traffic of public walking somewhere in the vicinity. And of course, never talk on the elevator about people and services. Everyone knows that's a given. Don't give out your passwords to anything. If your relationships are starting to go bad at home, we've had situations with significant others putting that little device on the email so they can receive your emails. Well, of course, them receiving your emails is a violation, and it causes a significant problem. So if you're in a situation where your home life is going bad, you may need to be proactive and change your passwords if it's that disgruntled between the two of you, because we've had more than one situation where the spouse, getting ready to be ex-spouse, is contacting me with false allegations against the staff to get them fired or get them reported to the state. So please always be aware of those things. Think of what you're throwing in the trash, because protected health information does not go in the trash. It goes in the box for shredding. So if it has even remotest thing close to a client's name, it does not go in the trash can. And you don't do like this and just tear it in half, because I can still read it. Just the tear does not actually mess up anything, and you will be able to actually read what's on there. So again, anything with client or consumer identifying information, it actually needs to go into the shredder box. On page 29, again, you have some staff contact information for Liz Bennett, as well as some contact information regarding staff records and subpoenas. So questions on HIPAAs really don't get caught in a problem. I typically am easily accessible via email. It's just shoot me a quick email. Even if I'm not in the office, I typically respond fairly quickly, even if I'm on personal leave, unless I'm out of the country. So just shoot me those questions instead of getting in trouble. I'd rather us work on it on the front end instead of trying to fix it on the back end. Number 11 on the Business Code of Conduct is employee relations and professional conduct. Now, this is where we start getting into our harassment policy, hostile work environment, problems with interpersonal skills with your colleagues. Now, when we're talking about harassment has some clearly defined terms associated with it. A lot of times staff think of harassment in more of a layman's term. However, for reporting purposes, I need it more for a legal situation. So when we're looking at a legal situation, harassment occurs because you're in a protected class. So is the person harassing you because of your race, because of your age, because of your gender? What is the reason you're being harassed? That's what you need to think of right before you call me or shoot me an email. So if you're being harassed because you're pregnant now, and it seems like your supervisor is messing with your schedule and doing things to you solely because you're pregnant, that is a protected class. Your pregnancy status is a protected class. So there is a reason for you to actually report that if you feel like you're being negatively impacted solely because of your pregnancy. Now, this does not include when you and a coworker just really don't like each other. Even if you call and try to use, they talking to me like that because I'm Hispanic. They're interacting with me like that because I'm African American. I'm going to have to vet that information out. In the past, on occasion, it was not the racial issue that was the problem. It was the interpersonal issues between those two staff. They just didn't like each other. Not liking each other is not a protected class, and then they're not getting ready to make up one. So that's an interpersonal skills issue that will be handled by management, by your supervisor and HR services. It is not necessarily a legal issue. Now, if you have a legal issue, someone's making offensive remarks that you don't appreciate about race or gender or creed or color, then yes, we have a problem. Be careful with your jokes. A lot of times you will tell an inappropriate joke to someone thinking they could appreciate the sexually inappropriate joke or the racially inappropriate joke, when in fact they cannot. And that is a reportable offense. I always tell people when you're telling jokes and doing stories and things, know your audience. I know Cindy Kigg, so I know how far I can go with my jokes. And I can go really far. But another staff I may not know as well may not appreciate that particular joke. So always know your audience. Pay attention to everyone who is in earshot, because while everyone's going to laugh, there was one person who probably didn't appreciate it, and that's going to be the one person who calls and contacts and reports you. And that is a legitimate reporting. Always be aware. We've had a situation at one of the clinics where two staff always talked about their antics, their sexual exploits over the weekend, very graphically. Well, the person in the office next to them was very religious, and she had a significant problem with the communication that they were having, and she didn't appreciate having to hear that every Monday morning. While they were not intentionally trying to harass her, the fact that she so very clearly can describe their conversation and so forth, she was negatively impacted. So it was affecting her environment, her work environment. So I did have to step in and address that issue because it ended up being a work environment issue. So if you actually feel you're being harassed, you think there's a hostile work environment that's being created because of behavior of your supervisor or a team lead, you have some individuals that you're supposed to contact. Our policy gives you several people to contact. I have said for years, call me directly, email me directly, and we can discuss it. The reason I always say skip all those other people in the policy is because I'm the one who does the investigation. So if you actually do have an harassment issue, the only person who's authorized by policy to do the investigation is myself. So if you tell your supervisor, and then they call HR, and then HR finally calls me. We've done a little bit of looping. You've having to tell your story more than one time when you can directly access me, Don't ever let anyone tell you you cannot access me directly. You can access me directly and I can get the information. We can talk about confidentiality and any of those concerns. So again, you do not have to go to your supervisor first for harassment issues. You can come directly to me, and that is my preference. It's my preference because sometimes supervisors and others want to work on the issue before it's sent to me. And I question some of them because they have not had true harassment training. What we're providing to you is harassment knowledge. I mean true harassment and investigative training. So I would prefer that to be done by myself, who is the person approved to do it by policy. So please contact me. We will discuss it. I typically will start an investigation within 5 business days. They go as long as they actually need to. I try to limit who I need to talk to, but on occasion, there's a legal questionnaire that goes out so I can see the degree of the problem. And I typically will use the questionnaire when the hostile work environment is the issue and it's not just a harassment of a one-on-one or one-on-two situation. So we do try to limit it. You cannot say, don't use my name. Your name isn't used to a certain degree, but the final reports are given to our CEO and whatever affected department. The CEO and HR always get the report. But say if it's one of Jerry Furchauer's, who is our COO's departments, and he needs to be aware of what's going on, Jerry may have access to the report also. So, but staff do not. Your colleagues will not have access to the report. I do not disclose names on my reporters to any staff. Staff will assume they know who reported, and half the time they are not correct, but they do run on assumption. But we do not disclose that information. We do have a no harassment policy here at the center, so that is not tolerated when it's reported. Please stop holding harassment reports because you don't want to be have an ill effect at your job. I've had harassment reports not reported to me solely because they didn't want the retaliation of the supervisor or manager of that program. Your manager and supervisor will never win with me on retaliation. The second you think your manager or supervisor is retaliating against you because they believe you're about to report or you have reported, all you need to do is call me, and I guarantee you that retaliation stops. So, but I need to be made aware of it in order to intervene. But retaliation or fear of retaliation is not necessarily an issue because all you need to do is call me. And I do understand that there have been retaliation in programs previously, and then once I found out, I did go address it. But no one called me. I found out by happenstance. Y'all really need to be reporting retaliation in your program. We do not want supervisors and managers out there retaliating against staff. Period. So once you let me know that they're a person who retaliates, our CEO is not supportive of that type of environment, and so she does allow me to address that particular issue with the termination. Now, when I go in to look at harassment, there are 4 things I'm really looking for to confirm it. The frequency of the event or action. By law, there has to be a certain level of frequency to it. The severity. What was it that they actually said? I mean, did I walk by and Rick Elizondo said, "Linda, your booty is big"? If that's all he said, I'm offended. Of course, but that's not necessarily harassment, and it only happened one time. Now, if he says it every single day, he makes a comment about my body part, he has slipped over into harassment because of the frequency, which is the first bullet. So frequency is very important, and whether the action was physically threatening or intimidating, some of that is subjective. I don't scare real easy. I'm not intimidated real easy. So something that would concern someone else may not concern me, but it has nothing to do with me. I need you to report that which is offensive and concerns you. And whether or not it unreasonably interferes with your job performance or was a mere utterance. Rick making a comment about my derriere is a mere utterance. It is not something for me to report if it actually happened one single time. Again, I need some repetition, but I want y'all to report at the beginning so we don't get to the level of repetition and someone having to be termed. If you report early enough, we can get in, potentially do training for the individual because it hadn't become pervasive or that much of a problem. And maybe the person just isn't aware that they're being as offended because sometimes the person doesn't say. And this is not just a woman on male thing or a male on woman thing. We've had sexual harassment go both ways in this particular situation. And while I do know it is sometimes uncomfortable for our male employees to report sexual harassment by our female employees, it is important that you report that information so we can make sure that we have good environments here at the Gulf Coast Center. Now, when the investigations are going on, there is a certain etiquette involved. Now, first, let's start off with Not everyone can do an investigation, nor should you be. By policy, there are only a couple of people who are authorized to do investigations. Myself, the CEO, will call for one. HR Services is allowed to do one. And of course, James Rollins does one when there's a vehicle accident involved and when that's reported to him. Anyone else who appears to be doing an investigation is in violation of the policy, and you need to call me immediately. It may be, though, I am a person who can do an investigation. I can ask a person like Chris Warner to do a leg of the investigation for me. We can designate things for staff to do for us, but you can't do it out on your own. So wait for us to ask. Your role is to report, and then we look and vet the information. Don't look and vet the information for us. We had a situation at one of our programs where staff questioned what one of their fellow colleagues were doing, and so they gathered information before they reported it to me and Cindy. So while they came in with a stack of stuff, they've gone through his emails, they followed him while he was gone, they went through his inner office mail also too, to prove up their point that this person was doing something suspicious. But in the time frame that they did all this stuff, they created a hostile work environment. If you look at those 4 elements I look for in harassment, did them all. But they weren't trying to do anything bad. They thought they were doing something good, getting all this information from me and Cindy. But you're not authorized to do an investigation. You need to report it. I may have asked them to go look at his inner office mail. I may have asked them to follow him when he left the building, but you need Cindy or myself to authorize you to do such. Otherwise, while you're out there investigating, following him around and all that, who's doing your case management? Who's doing the job we actually are paying you to do? Because that's not part of it. So it's important that we all realize that we all have different roles, and your role in this situation is to report and allow us to go out and vet the information. Now, if you're involved in an investigation, you can't lie, you can't steal information or destroy information or mislead the investigation. Any of that behavior will result in a termination. We've actually had an individual, Cindy was in the middle of the investigation, had already seen the offending piece of paper. By the time she talked to the staff denied it ever being in the chart because the staff took it out the chart and shredded it. They did not know Cindy Keck had already seen the piece of paper. That is an immediate termination. Staff make mistakes. There is not a problem making a mistake. Fall on your sword and admit the truth, and typically we work with the issue if it wasn't something like intentional fraud. Your biggest savior in a termination hearing is being truthful and acknowledging the fact that you did something wrong. That says something about your character, and that means you are trainable, and there's a potential you won't do it again. But if you continue to lie, you will actually be termed. But again, there is an investigation etiquette involved with my investigations, with Cindy's investigations, with Janine McNulty, who's over HR investigations. So be aware if you lead, mislead, or destroy information within an investigation, or break the rules of the confidentiality surrounding that investigation, there will be a request for termination, and you will be termed from the center.
Number 12 on the Business Code of Conduct is customer focus and consumer-client relations. This is where we move into the rights protection portion of this training. You'll see there that it states that we need to make every effort to advance the welfare and the best interest of the people that we serve. We need to treat people with positive regard. We need to be courteous, and this includes family members, and mistreatment in any form is not going to be tolerated. Consumer-client relations is slide 34. It states that all consumers deserve to be treated with dignity and respect, be involved in their care. Everybody that we interact with, family members, people in services, need to be treated with dignity and respect. Mistreatment in any form is not going to be tolerated. Please be sure that you understand the rights of the individuals you serve. Each division has their own set of rights. There are rights in mental health services, in IDD services, and recovery services. No one understands those rights. So you don't violate any rights, and also so you can make sure that the individuals that you serve know what their rights are. There are handbooks that you need to be aware of, and again, be familiar with those rights so you can work effectively with the individuals and services.
On slide 35, to complement what Cindy is saying about the protection of client rights, it's important that you understand there are some forbidden consumer-employee relationships. Now, as you look at the list that's on the slide on 35, most likely you're thinking, yeah, I would never do that. Unfortunately, we have had staff who have used faulty judgment and potentially got into one of the situations that are indicated on this slide, which is a violation of our Code of Conduct, number 12. So, as a center employee, You cannot date people in services. Now, the only window of opportunity, if you're thinking, ugh, why did she say that? If you and that individual were dating before you became employed at the Gulf Coast Center, of course you don't have to break up with them. If it was an established relationship, the center has nothing to do with it but make us aware that it was an established relationship before it pops up to be an issue. But again, an established relationship, not a problem. If you're sitting at the reception desk and someone walks in and catches your fancy, he just has to catch your fancy from afar. You cannot get his phone number out of this chart and call him. You cannot solicit a date on secret or none of that. If you are an individual who works at the Gulf Coast Center, you cannot date individuals who receive services at the center regardless of what side of the house they are on. Now, if we tell you you can't date the individual, you should assume you cannot have sex with them either. But because someone doesn't, not all of you make that assumption, I want to tell you out loud, you cannot have sex with individuals who receive services at the Gulf Coast Center. And that does include the phone sex, the sex pictures, and everything related to a sexual in nature contact with people who are in services. It will always cause you a problem. And I know y'all think, well, how would you ever know about the sexual conduct? Because when y'all stop the special relationship, they send me your little naked pictures, your little devices, your little text messages and everything between to prove that you did something wrong. After they have reported you to the state, reported you to Cindy, and reported you probably to anyone who picked up a Gulf Coast Center phone before they got to the appropriate person. So the relationship typically will be found out. Staff have tried to mislead investigations in this situation. However, when a client or consumer can describe all the tats on your body in the private areas, of course, that will be something that, kind of lends towards the fact that y'all might have had an inappropriate relationship. But we will look at everything. This probably will come in under DFPS first, so the Department of Family and Protective Services will be doing an investigation. And after that, I will be able to do mine. Any confirmed sexual conduct in any type of nature by any staff will actually end in termination of the staff. So again, reported sexual conduct that is actually confirmed actually does result in termination. So no dating, no sex in nature with those people who receive services. Now, with that said, no living arrangement agreements either. If someone's receiving services here and say they need a roommate to share in rent and you wouldn't mind saving a little money, you cannot go save a little money living off of someone who receives services. It's called exploitation, and there genuinely is no way to get around that rule. And the situations where this actually occurred, which required it to make it to this list, the person wasn't actually trying to do anything malicious. Actually, the family member wanted our staff to live in the house with the client because whenever our case manager came around, the client would cook and clean and dress themselves up in anticipation of the appointment. So the family recognized that, the client recognized that, so they thought our staff being there on a regular basis would actually be beneficial to the client. And while it could have been beneficial to the client, it was completely exploitation under the rule. So unfortunately, it was not something that we could approve. So there are no living arrangement agreements that actually can work when you're just trying to be the roommate with someone who receives services here at the center. No loans or storing of consumer funds or money. This always tends to bite staff in the butt. Unfortunately, I have to use that terminology. We've had staff who have done it maliciously, and we've had staff who thought they were doing a favor for a client or consumer holding the money so they wouldn't spend it, and I'll let Cindy discuss that in the exploitation section. So remember, we have a monetary gift rule. We have a gift rule. You can't accept cash. Our gift rule doesn't allow you to accept cash. It allows you to accept a gift up to $50 in value. They cannot hand you a crisp $50. They can't hand you $25. They cannot hand you dollar bills. They can provide you with a gift. So please understand there are limitations within the gift policy. Monetary gifts are out, and recovery, again, remember you can't accept gifts regardless, whether it's monetary or an actual pair of earrings. Don't have consumers doing chores to get extra privileges. We previously had a program. I actually was sitting in the room. We were waiting to do a client rights training. And a client walked in up to the front desk and asked the staff, could he have a cigarette? The staff's response was to hand him a plastic bag and tell him to go pick up the trash in front of the building. They'll be more than happy to hand him a cigarette. that is a violation of the Department of Labor. We can't have consumers doing stuff we would actually pay someone to do. We have a lawn crew. So come to find out, as Cindy and I asked questions regarding this situation, they actually had clients cleaning bathrooms and all kinds of stuff for cigarettes, so we actually had to intervene and stop that. So while it sounded like a good idea to them for some reason, it actually is not allowable. So if you're doing skills training and someone's trying to get a job at a car wash, they cannot be washing your personal car as the skills training. It actually is not going to pass muster. So if you're doing that, stop. And we won't have any issues. Always be cautious of the 3 last bullets on 35. Telephone communications. Please always remember, someone who's listening in on a conversation can only hear one side. So you may only hear what Cindy is saying. You won't hear what the person on the phone is saying. So there's always an allowance for misinterpretation. So if you're the one talking and you're trying to redirect someone, maybe a client or a consumer has called you and they are speaking very sexually, and you're trying to redirect them, be very clear in your notes that that's what occurred in that phone call, because someone walking by may only hear one little word, and that may be, "Stop talking about my boobs." Well, then they may stop and think, why are they talking about boobs on the phone? And think y'all are having an inappropriate conversation, when in fact you're doing the therapeutic thing and redirecting that particular person. So make sure your notes are very supportive of a communication when you have a communication that has a potential to be suspicious. The next caution is getting into relationships, business relationships with those in services. They tend to end badly for staff, because if it doesn't go smoothly, your recourse is somewhat limited. We had a staff person who needed his AC worked on. He was looking up vendors or something at his lunchtime or at some point, to where a client actually saw what he was doing and mentioned that he does that work. Made an agreement, the client would go to the house, fix the AC, staff paid, AC actually wasn't fixed, so staff stopped the check. That meant client called DFPS and everyone under the sun and made this one personal issue, because the AC getting fixed is a personal issue. Made that one personal issue a business issue, because he brought in everyone from business to deal with it. He brought in DFPS. There's a rule, they have a stronger rule about what types of relationships you can have with people in services for recovery. And so violations did occur when staff honestly did not think anything was going wrong. Had they went through the phone book and found an AC vendor and stopped payment on the check, that would have never made it to the Gulf Coast Center. But for the fact they were using someone who was in services, it got really muddy. That's why I say it's a caution. It's a chance that it could go bad solely because the person is in services. So if I was you, I would not get in the relationship, and you definitely should not have them go into your house, because again, they have now personal information they can use to misrepresent what type of relationship you actually have. So it is a caution. But it's a caution that has ended up in a termination of employment for several individuals, because it did actually go bad. Our hands were tied, and we had no choice but for the rule to term our employee, whether we agreed with it or not. And again, the last one is avoid the appearance of inappropriate behavior. There are, of course, times when there's a male and a female situation. Maybe the staff is female, the consumer client is male, or vice versa. There have been times when we've had staff pick up consumers from the hospital. Well, sometimes those rides are long, so there has been occasion where staff have stopped and gotten something to eat. Well, say it's me and a male consumer sitting there eating. It's 6:30 because it took us that long to get through Houston traffic to get back to this county. So we stop somewhere and eat. It's nothing fancy. It's probably Chick-fil-A. But someone sees us and it looks like we're on a date or inappropriate. They're going to call it in. So it gives the appearance of something inappropriate, but there was nothing inappropriate going on. And when they go back and look at my notes, it will be very clear why me and that person was together. So again, this is the importance of accurate documentation. But appearance can cause a problem. If your documentation is there, appearance won't be a problem, because we'll know to actually view that as unconfirmed or something that's not suspicious, and everyone moves on. But it's important for us to be aware of situations like that, because situations like that have been reported, whether staff were right or staff were wrong. But we will look at all of them to make sure that we are actually being compliant with the laws and set an environment that works both for staff and those people in services.
We have a number of slides on abuse, neglect, and exploitation, starting with slide 36. But before we do that, let's talk just a little bit about the complaint process. On 12 on the Business Code of Conduct, toward the end of the paragraph, it states that the center has established processes for the prompt resolution of consumer client complaints and grievances, including informing individuals who to contact for a complaint. I mean, just know that we broadcast how to file a complaint. We have posters in all of our facilities with my contact information, the state's contact information, DFPS, licensing boards. We make it known that we want people to file a complaint if they have one. And we really do. If someone is disgruntled or unhappy, the best thing they can do is file a formal complaint so we can investigate it and look into it. I say that so you will know to not be surprised if you get a complaint. Honestly, I don't feel like we get as many complaints as you would think for the number of people that we serve, but we do get a few, but we have to have a process to resolve them. And we have to have an effective process to resolve them. And believe me, you may not want to talk to me if I call you about a complaint, but you would probably rather talk to me than the state. So we really do want to try to resolve these issues at the local level so they don't have to go further. And if they do go further, the state will usually contact me and ask me if I'm aware of it, and then I explain, how we address the complaint. So it really is important that we have options for people, so anything that's concerning them with our service delivery can be thoroughly investigated and resolved. I'm not just trying to find your fault. I'm not trying to get you or anything. Basically, an investigation is just a collection of facts to try to figure out what happened. Sometimes we are in the wrong. Sometimes we should have done something differently or better. Sometimes that's not the case. And then my role would be to explain to the individual why the situation played out like it did. But basically, I'm just trying to determine what happened. So please cooperate with me and help me to resolve any issues that come up within the programs. Okay, back to slide 36. Abuse, neglect, and exploitation. First of all, we want to prevent it. We do not want anybody at the Gulf Coast Center involved in abuse, neglect, or exploitation of individuals in service. This slide talks about just some things you can do to kind of help keep yourself in check so you don't find yourself in a situation where you're going to do something that you regret. First of all, learn your job. Know what the expectations are so you're not all stressed out about what your job duties are or how you're supposed to fulfill them. Ask questions. Know what you're supposed to do and what your expectations are. Communicate. You need to communicate with your supervisors and your coworkers, especially if you have questions or concerns or need assistance. If you're frustrated about what's going on in the program, address it. Don't take your frustrations out on people in services or their families. We need to have high morale and foster good relationships within our program so we can provide a good service to the individuals that are here counting on us to do so. Stress management. You need to manage your own stress levels. I just can't even stress that enough. Stress makes people do unfortunate things sometimes. So try to keep that in check and do what you need to do to keep yourself healthy so you can provide a good service to the individuals that are here counting on us. Personal problem management. Try to leave the personal issues at the house. I know that's not always possible. We all have things come up in our life from time to time, but if they begin to affect your job, you would be well advised to alert your supervisor. Think about it this way. You have a personal issue that's beginning to affect how you perform your job. It would be far better if you spoke to your supervisor on the front end and basically explain the situation. You may need some extra time off, whatever. Get that addressed and settled up front, as opposed to you not saying a word and then your job performance is affected and then your supervisor brings it to your attention. See the difference? It's very important to everybody work together to have a good, healthy environment in our program so we can provide good services. The next 3 slides talk about signs and symptoms of possible abuse, neglect, and exploitation. These are just things to be alert to. You don't have to be, the police for every Band-Aid or any possible injury that comes up, but we do need to be alert because sometimes us or people in the human service field, we may be the first person to recognize that someone is being abused, neglected, or exploited. So please be alert to these things. Signs and symptoms of possible abuse. You can see it's things like multiple scratches, cuts, bruises, burns, unusual patterns of injuries. For example, cigarette burns in a circle is not an accident. That would be something to be alert to. Inadequate or illogical explanations. A lot of times people that are being abused will protect their abuser and come up with fairly lame excuses for various injuries that they're having. Someone who has lots of injuries, just is very accident prone and has injuries all the time. Making odd comments like reports of confinement. We've had people just off the cuff in services say, my mom locked me up last night so she could go out. Okay, that's confinement and that's not okay. Reluctance to participate in a physical exam. We've had that happen as well, where a female staff and a female client were at the doctor for a physical, and the client was very nervous about the exam and was asking the staff if this was going to be a pelvic exam. And the staff was like, well, no, it's more of a, take your temperature, look in your ear kind of physical, very simple physical. But the staff was alert to the fact that this lady was so concerned about that. It made her ask a few more questions. And as she delved into it, come to find out the lady was being sexually abused by her father. So that staff was then able to take action, report that Adult Protective Services, the lady was removed from the home. All that happened because the staff was alert. I mean, just imagine if they had been sitting there, but the staff was not engaged in the waiting room, was ignoring the client, reading a magazine, and not talking and engaging with this individual. That might have never been discovered. Another one is passive withdrawal behavior around certain people. This could be especially true of our folks that are nonverbal. Just look for signs and behavior that might indicate that someone is afraid or real nervous around a certain person. Signs and symptoms of possible neglect: lack of food or water, over-medicating, under-medicating, inadequate shelter, unsanitary living conditions, untreated health problems, lack of personal hygiene or clothes. Now, neglect is kind of a strange situation here. You can't just look at the list and say, okay, everybody I serve is being neglected because this person has poor hygiene and this person doesn't want to take their medicine. With neglect, you have to see or think about who is responsible for this situation. And it may be that no one is. If an individual is over the age of 18, they don't have a guardian, and they don't want to take medicine, that's a choice. Now, hopefully it's something that we're working with the individual on to try to explain the benefits of why medication is needed. But we can't actually make somebody take medicine. So that could be a self-neglect situation, but you're not going to be neglectful because the client won't take the medication. Same for the other situations. Lack of personal hygiene or clothes. Again, a person may have issues with hygiene. That's not going to be neglect on a staff person because a person won't, take a bath or shower regularly. Hopefully, again, it's something that we're working on that individual with as far as, their daily living skills and hygiene and assisting them to get clothes if they need them. But we can't make people take a bath or change clothes. So neglect's just, like I said, a little bit different. You have to think about who is responsible. Let me contrast that with someone, say, that uses a wheelchair and they have someone who is responsible for taking care of all their health, their self-care needs. They can't bathe themselves, they can't comb their own hair, that kind of situation. All right, if that person is soiled, their hair's matted, and you can know that there's someone responsible because they can't take care of those things themselves, then yes, that very well does seem to indicate a situation where neglect could be occurring. Same with medications. If an individual cannot take their own medication and there is a home health or a family member or a guardian that's supposed to be making sure that the individual takes their medication and they're not doing it just because they're forgetting to fill the prescription or they're just being negligent basically, well then yes, that could be a case of neglect because the person can't make the decision to take their own medicine or not. Someone is supposed to give the medication to them. So that's just some examples of how neglect is a little bit different. But don't hesitate, even if no one is responsible for the situation other than the person, to contact Adult Protective Services and report self-neglect because they will investigate that as well. In fact, I've had investigators tell me in the past that the majority of their cases are self-neglect cases. Examples of exploitation is slide 39. You can see taking, holding, borrowing people's money. Stay away from people's money and belongings. You will find yourself in a very unfortunate situation if you get involved in any of those kind of circumstances. The example that Linda alluded to earlier was the lady that worked here that was going to hold someone's money for them. She later told us that she had a really good relationship with this individual. They worked together, she knew him a long time, and when he came to her and gave her $100 and said, would you please hold this for me because my family was supposed to come into town this week and now they're not, but if I keep this money, I won't have it when they come next week. So the staff person who told us, she remembered that she shouldn't do this, but she thought she had such a good relationship with this individual, she's going to go ahead and do it. Okay, big mistake. She puts the money in her drawer. I mean, we had no thought that she was going to, intend to keep it or anything, but she did hold it, and she put it in her desk drawer, and the client left. Okay, over that weekend, the client gets sick. He decides he wants to go to an urgent care, so he goes up to the program to get the money. Okay, the program's closed. It's the weekend. There's no one there. So the individual doesn't say, oh, well, I'll just get it on Monday. I know she'll have it. He goes home and calls Adult Protective Services, and he reports that he can't get his money from a Gulf Coast Center staff. So that's an immediate exploitation investigation. Then they ask him, what does he need the money for? He says he doesn't feel well and he needs to go to urgent care. So then that staff had a second investigation for medical neglect because he was unable to go to the doctor because she had his money. So that is just a real example of how quickly something that you don't think is offensive or going to be any problem can quickly turn into a problem because of the circumstances. So don't borrow money from people, don't store money, don't hold money. Another example is the individual who actually borrowed $20 from someone in services, paid it back. Then it was discovered, then it was reported to Adult Protective Services, it was confirmed, and that person, actually she was a contract worker, so she was terminated by the contract provider. She had already paid the money back by the time the investigation went to APS. That's not the point. The point is she borrowed it in the first place. We should never, ever use the people that we serve as a bank or to help us because we're short of funds. It's totally unacceptable, and it will land you in an exploitation investigation. Of course, other things, you wouldn't take people's checks, you wouldn't take people's property from them, you wouldn't exchange things of unequal value just because you suspect maybe they don't know the value, so maybe you can pull one over on them by trading something inexpensive for something more expensive. You can't ask people to buy things for you. Any of those things could be problems, and Linda already talked about not using people as free labor. These are all examples of potential exploitation.
Now, one example that's an exception that has come up numerous times is those clients who sell their little art and mosaics and stuff on the seawall and on the strand. As long as you're purchasing it at fair market value that anyone who's walking by the stand would pay, there's not an issue. As long as you don't get the 5-finger Gulf Coast Center discount, you're not going to have a problem. So if you're paying what everyone else would pay, you can buy someone who's in services art or work. They come up here and they're doing ceramics and they're $25 and they're always $25 regardless of where he's standing. You can purchase it from him for $25. If he's selling something for $25 and you tell him you will only pay $5, and everyone else always pays $25, that would actually meet exploitation, that $5. So as long as you're paying fair market value for whatever a consumer is selling, you're not going to have an issue under exploitation.
One more issue that comes up. Staff sometimes ask if it's okay for staff to buy things for people and services. Okay, now that's not the same thing as exploitation and the client buying things for the staff. And it's not prohibited, but it is cautioned. You need to think about boundary issues. If you start buying and spending a lot of money on somebody that you serve, you're going to start graying some boundaries with your relationship between them being the person in services and you being the professional. It's going to get too friendly. We've had some serious problems created in the past because, and I realize that staff are just being kind-hearted, but you need to think it through more than that. You need to think about the boundaries and what kind of example that's setting for that relationship, and just be cautious of that.
Because your good intentions isn't always an excuse. Unfortunately, it doesn't work with DFPS or the state. We may give an allowance on our end, but your good intentions in a situation of exploitation and abuse or fraud or any of that, it has no weight, unfortunately.
Slide 40 talks about how to report allegations of suspected abuse, neglect, and exploitation. This is in mental health services and IDD services, and we'll talk about recovery in just a second. Everyone has a responsibility to report. That is why you have to go through this training every year so you know what the expectations are. It's not just me as a rights officer or management, every single person. And the person that needs to file the report is the person that received the information firsthand. The first-hand recipient of the information is the person who's going to have the clearest information to file the report with APS. So if you have something reported to you by a client or a consumer, or you witness something, then you are the person that needs to make the phone call. And this is how you can report it. There's actually a phone number, and there's a website also. You can use either one of those, and those are listed on your slide 40. The decision is yours, but you need to make the decision promptly. You have the definitions of abuse, neglect, and exploitation in your handout packet behind your business code of conduct, and those are the definitions as provided by the state. So keep those definitions handy, so if you ever see anything or something gets reported and you're trying to determine if it's something that needs to warrant a call to Adult Protective Services, you can whip out those definitions and review them. You need to do it within 1 hour. The reg says 1 hour. They don't want you sitting on it. They don't want it to be Friday afternoon at 3 o'clock and you hear something or you see something and you think, well, it's late in the day. I think I'm going to worry about it. Wait, Monday's a holiday. Okay, I'll do it on Tuesday. That's not okay. These things need to get reported depending on the seriousness of the offense. APS has certain time frames to make contact with the individuals, and so you really do need to make that decision and get those reported in that time frame. If you review the definition and you really don't think it meets the definition or you're not sure, it is certainly fine to go ahead and make the call to Adult Protective Services intake and tell them the situation. If it doesn't fall under their jurisdiction, they will tell you that. But at least if you're unsure, you've reported it and they've had a chance to weigh in on it, and you know that you did the right thing by trying to report it, or if they took the case, then of course, obviously, you should have reported it. Do not notify the alleged perpetrator if a case has been called in on them. And I know you would probably think, well, who would do that? Well, it's happened. It definitely has happened. We've had people just mention to the person that is identified as the alleged perpetrator of the case, just mention to them that the client just called and reported them. Okay, that is going to completely compromise the investigation. The investigator does not want anyone to know that the case has been opened until they get there to take the statements from the people involved. And you will compromise an investigation if you start sharing information with people. If the alleged perpetrator is a center staff, you will need to do an incident report and send that to me within 24 hours. That is not the case if the alleged perpetrator is someone else. It's someone in the home, it's mom, it's home health care provider. It could still be abuse, neglect, or exploitation and may still need to be reported, but I just don't need an incident report because it's not a situation that it impacts the Gulf Coast Center. That's different if it's a center staff that the alleged perpetrator. So that's when you need to do the incident report. Slide 41 talks about abuse, neglect, and exploitation in our Recovery Services Division. This is a little bit different. Keep in mind that if the individual that is the alleged perpetrator is a center staff, again, that does concern the center and we're going to be involved in that investigation. In fact, if the alleged perpetrator is a center staff and the person in services only receives recovery services, then that's an issue that is reportable to Department of State Health Services and also to me. I work with DSHS to determine how the investigation is going to play out. I may do the investigation and send my report to them. They may do the investigation. They can even reinvestigate after I complete an investigation. But those are the entities that are involved when the individual that is the alleged victim only receives recovery services. It's myself and Department of State Health Services. The difference would be if the victim is recovery and also mental health. The mental health diagnosis would bring in Adult Protective Services. So you have to kind of think that through a little bit when you're trying to report something in that division. Again, a mental health diagnosis brings in Adult Protective Services. If it's just recovery services, it's DSHS and myself. Just some guidelines for reporting. On slide 42, I already said don't notify the alleged perpetrator. Don't start your own investigation. That ties back to the slide Linda talked about investigation etiquette. And do not discuss the incident with other people. You can tell your supervisor, and of course you're going to tell me if the alleged perpetrator is the center staff, but it's not a table topic for lunchtime. It's not something to chat with your coworkers. Investigations need to stay and remain confidential so they're not compromised. You need to preserve the safety of the individual if that is applicable. For instance, if someone is physically abused and they have a physical injury, yes, you can help facilitate medical care, whatever might be needed. That's not going to be considered compromising the investigation. You're actually helping the person. You do need to protect any evidence. Evidence for us would be often any kind of documents, treatment plans, progress notes, and these are things that the investigator may ask for. They may ask for job descriptions, which I can get from HR. But finally, do cooperate with the APS investigators. The FPS, they are by law the entity that are designated to do investigations for entities such as the Gulf Coast Center. You must cooperate. They are not going to go away if you don't return their phone calls. They're only going to call me and make me call you and tell you to return their phone call. Believe me, they are trying to get their investigations done as quickly as possible so they can move on to the other investigations they have, and they have plenty. So please work with those individuals so we can get those investigations wrapped up. Okay, now that I've said you cooperate with the investigators, slide 43 is actually when we do not cooperate with investigators. It's a unique situation, but it's very valid and it does happen. So that's why it's a slide in here. So to help you remember, and you can even reference this if you need to. This comes from the interpretive guidance on laws pertaining to the privacy of mental health and mental retardation records for the mental health service delivery system. Okay, this is information straight from some HIPAA guidelines about releasing information in investigations. So here's the key to remember. If an investigator calls and they're asking for information on the individual we serve, and the individual we serve is the victim, that's fine. We cooperate. We work with the individual to get the information needed to assist with the investigation. It is not the same thing if an investigator calls and they want information on the alleged perpetrator, and we serve that individual. That's when we say we're not able to do that unless we have an authorization or a court order. So here's an example. Say a CPS worker comes into our adult mental health clinic. They've already been to the children's clinic and they've received information on the child, who is the victim. We serve them, we provide information on the child, and we cooperate. Then they go to the adult clinic where we serve mom, who is the alleged perpetrator. They want information on mom. They want to know, is she coming to her appointments? What's her diagnosis? What's her medication? That's the no. That's the no, you have to have a release or a court order. We've had some conflicts over this from time to time, and it's sporadic, but every now and then we'll have a CPS or even an APS worker come in and want information on the alleged perpetrator that we serve, and it's just no. You can try to resolve it. You can refer it to your supervisor. Most supervisors are well versed in this because it's happened a few times. Or you can send it to Linda or I, and we'll weigh in on it and make sure that the individual understands it. We are not impeding the investigation. By law, we do not release information on the alleged perpetrator. On slide 44, we talk about what happens when a DFPS investigation occurs. Once you report through the 1-800 number or the website, APS is going to contact me, because I'm the liaison for the center, and let me know that an investigation has started. They will give me basic information through an intake. They will tell me the alleged perpetrator, they'll tell me the victim, a brief summary of the allegation, but they will never tell me who reported it. They always keep the reporter confidential. Now, I'm going to know because you're going to have already done an incident report to let me know when it's a center staff that's the alleged perpetrator. But just know the DFPS never divulges the name of the reporter. Okay, once the investigation started, the center is not involved in that at all. In fact, I don't even know what's going on. I check back every now and then to see if it's been finished or if it's been extended, but they do not keep me updated on how the investigation is progressing. We typically just wait until we get the investigation. That's when we find out what the outcome is. When I receive the report, I'm going to send the report to Melissa Tucker, the CEO, and I'm going to send it to the review committee, which is Linda Bell, Jerry Freshour, and Janine McNulty, the HR director, the COO, and of course general counsel. That group reviews all investigations, and when they're unconfirmed or inconclusive, after I've given them the opportunity to review the report, I'll check back with them a few days later, ask them if they agree with the findings, if they have any comments, and then we close it out. And that's very simple. It's entered into the care system. We're done with it. It's unconfirmed or inconclusive. And then I notify those involved, the staff person who was the target of the investigation, the supervisor, and the individual who was the victim. I notify everyone of the outcome of the investigation, and we're pretty much done with it. It's not the same process if the case was confirmed. In those situations, I will still give the report to all those individuals I previously named, but I will also give the report to you, if you're the targeted staff in the investigation, and to the supervisor. And the reason for that is everybody needs to have an opportunity to review this investigation and weigh in on it. We don't close those out by email. Those we actually have a meeting. It's basically due process for staff. We sit down at a table, all the people I just named, myself, your supervisor, you, and it's your opportunity to review the investigation with that review team. Tell them what you think of the investigation, whether you think it was fair, if there were elements that weren't considered. And once you present your information, you leave, and the review committee makes a determination as to whether or not to agree with the findings of that investigation. They may choose to disagree based on the report itself. They may choose to disagree based on information that you've provided. The bottom line is we do not have to agree with a confirmed case if we do not feel the investigation was appropriate or accurate or warranted. So,
the only catch, let me say this, if an investigation is called into DFPS, but there's another issue that's actually reported to Cindy or myself, because we're in that situation right now, we will not move forward with our side of the investigation until DFPS is finished. So, there's a DFPS investigation for abuse or sexual contact with a client. If we have a staff report on this side saying that that particular individual is actually harassing staff, employees, at the center too, I can't actually go in and do my harassment investigation until DFPS has closed out their investigation. That rarely happens, but it is happening actually right now while we're making this tape. We're on hold for an investigation waiting on DFPS to close out. So it's a rare occasion that two come in at the same time, but it has occurred. But again, we do not overlap in the investigation. We let the DFPS investigation close out first, and then we do our investigation. So a staff person may end up unconfirmed under DFPS, but actually termed under the Gulf Coast Center policy and business code of conduct. The next thing on the business code of conduct is number 13. It's controlled substances. I mean, it's kind of a given. You should just assume you can't come to work drunk. You can't come to work high. I mean, I would think it's a given. But you will get termed for that. If you're in Connect, of course, you're randomly tested. If you're in a safety-sensitive position, you are under random testing. Staff who just work for mental health services, disability services, recovery services, you're not on a random call list, but you can be tested for cause. Tested for cause is approved by myself or Janine McNulty, HR. Tested for cause means someone has to call and give me a reason for me to require you to be tested. So, you're stumbling. You smell like weed. They can smell the alcohol on your breath. Your eyes are bloodshot. Those things are objective, and if they call me with those, yes, we will approve for a test to be ran on staff. And so staff either go get tested or they allow that to be their last day. Does that happen on any level of regularity? No. Will you have to have bona fide observable things in order for me to approve a test on alcohol test on an individual? Yes. It has to be more than I think she's drunk. I need more than I think she's drunk. I need her to be stumbling. I need her to be slurring her words. I need her eyes to be bloodshot. I need those things medically that support the fact that this person is impaired. We've gotten a call. Well, I've received a call once because the staff in the program could not wake up the staff person. She had a head on her desk and they couldn't get her to wake up. So they called me for a drug test. I was very clear in that situation. That was not a drug test. That is called 911 and you call an ambulance. You couldn't get a staff person to wake up. So I need y'all to use some common sense in this also too. Yes, that person may have needed to be tested, but because you could not get her to respond, a test wasn't going to solve anything. You needed to call an ambulance because that person could have been having a sugar issue and a host of other things, and the staff person, if they're just thinking she's high or drunk and just not responding. Even if that had been the case, and it was not, an ambulance needs to be called when someone is that incoherent. So do keep that in mind. And no, we do test for cause. You get randomly tested if you're in Connect or you're safety sensitive. But in general, and the real rule is, you do not come to work drunk or high.
Slide 45 is the final slide pertaining to client services, and it's reporting deaths. If you learn of the death of someone in services, you need to immediately let me know and do an incident report. I need to know cause, when it happened, and where it happened. I do have some reporting requirements with the state on the mental health side, and it's important that I have this information. Basically, we need to determine whether or not a full medical review needs to be done. If the individual's death was natural causes, then I can close that out fairly quickly. But if it's a suicide, an accidental overdose, something of that nature, then the center, Linda, will do a full death review, and it will go to our peer review doctor meeting, and all information will be reviewed. But of course, we can't make that determination until we know cause of death. My suggestion is that if a family member calls you and tells you that someone is not going to be able to make their appointment or their scheduled med check or whatever because they've passed away, certainly be respectful, offer your condolences, but do ask what happened. People will generally tell us that, you know, he had a heart attack over the weekend, a seizure, car wreck, and I can use that information that the family gives you to close out the case. Now, if the family doesn't know what cause of death is, they just say, you know, he died in his sleep, we don't know what happened, those are flags to me that there's going to be an autopsy. And in those cases, I don't have to get back with you and ask you to pursue that information. I will contact the medical director, the medical examiner's office directly and ask them to let me know the outcome of the autopsy when that's completed. So that's how I'll get cause of death, and then we'll be able to determine from that whether or not the full medical review needs to be done. But do the incident report within 24 hours and let me know immediately. I need to report the death in the mental health services by the next business day. So it's important that that's reported very, very promptly. We're almost done. We're up to 14 on the Business Code of Conduct, and that's reporting misconduct. That just summarizes all the things we talked about earlier when we emphasize the importance of reporting things if you think they look suspicious or you suspect noncompliance or any kind of misconduct or concerns. We need to get those things reported so we can investigate them. The final thing is risk reporting on the Business Code of Conduct, and you do have a couple of slides about that. Start with 46. Risk reporting pertains to our incident reporting system. It's an internal risk management document that just captures the unusual incidents that happen at the Gulf Coast Center. This is an electronic form. If you have any paper forms laying around, throw them away, because a few years ago we went to an electronic form, and you can find that on the center's intranet under forms. And you just fill in all the information. Please be thorough. When you get to the number where it says full description of incident, 9 times out of 10, one sentence is not going to be enough. It's not going to be enough information for Linda and I to understand what happened. That text box will keep growing as long as you type. So please give a very thorough explanation of what happened so we can understand the full extent of the situation. At the bottom of that form, there's a link that you click. It opens up an email to me, and then you attach it and send it on. There's a number of examples of types of incidents reports that you may want to write. That's slide 46. These are just kind of the ones that we most typically see. The ones that I need in 24 hours, you'll see on the next slide, 47. I've already said abuse, neglect, and exploitation when the alleged perpetrator is a staff, that's 24 hours. Deaths, 24 hours, because I have some reporting requirements. The other one is when you have an injury or the potential for a workman's comp claim. You fall down in the hall, you have a car wreck, you fall in the parking lot, a shelf falls off the wall on your head. Anything that impacts you and has the potential for an injury, you need to do an incident report immediately, and not only notify me, but when you do that link and send the incident report to me, you need to send it to Kelsey Hooser also, because she needs to be aware so she can notify the insurance in case there's a workman's comp claim. It's very important that you do that, because I know people fall, they don't want to do a report, they hope nobody saw them, and you don't. And then a week later when your knee swells up and you think it's related to the fall, then you want to let us know, and then we don't have any evidence that you fell here. We have no idea where that fall happened. So even if you don't get hurt, do an incident report so we have it on record should you ever need any medical care. And then again on 46, you can see there's just a number of examples of types of things that you might do a report on. It's accidents, car accidents for sure. Immediately notify James Rollins or his designee. Loss of property, fires, missing records, medical emergencies, mental health deputy calls. Again, just unusual types of incidents that occur within a program.
Okay, final thoughts. 1, there are no stupid questions. If anything we discuss pops up for you, please shoot Cindy or myself a question. We'll be more than happy to answer. You thinking it's not worth asking a question is never a good excuse when we can provide you guidance on the front end. Second, something I didn't actually mention under HIPAA, staff are not allowed to actually access a family member or neighbor's record. We've had occasion where someone thought, oh, let me go look at my grandchild's lab results, or let me go see what the medication list is of my nephew. That is actually a violation of HIPAA and the Gulf Coast Center policy and procedure. You need an authorization to access a family member or a neighbor or anyone's record if you're not involved in the care of that individual. At no point does an authorization allow you to actually access SmartCare or whatever system we're using at the time and actually view a family member's record. That will be a violation that actually ends in termination. And lastly, I had developed a legal reference list some time ago that was available for clients and consumers and staff. It used to be a part of the packet. Now actually it's a request form. So if you yourself or someone who you serve actually needs legal advice, please shoot me an email. Let me know that you need the legal reference sheet, and I will email that back to you in my response.
I want to say one final thing about incident reports that I failed to mention on slide 47. I already talked about the 3 that I need in 24 hours. All the rest of them, 48 hours. Please do get those in a timely manner so we can follow up on them appropriately if we need to. That concludes our corporate compliance and rights protection training. Be sure to sign in on that sign-in sheet in the training room and turn in the documents that I mentioned at the beginning of this training. Thank you.